Hello, everyone. Welcome to today's Title Topics webinar. This is ALTA's free 30-minute presentation we are offering monthly to provide alternative ways of communicating important industry information with our members. I'm Jeremy Yohe, ALTA's Director of Communications, and joining me today for the webinar is Bill Burding. He is Executive Vice President and General Counsel for Orange Coast Title family of companies. And he will be discussing Freddie Mac's short sale affidavit. And he's also a member of ALTA's Board of Governors. So, Bill, thanks for joining us today and taking a little bit of time out of your busy schedule to discuss the short sale affidavit.
My pleasure. Thank you. And welcome, everybody. Last year, we started running into problems. I'm sure most everybody on this call started running into problems regarding the short sales and the short sale affidavits. Freddie Mac came out with a short sale affidavit that they were requiring on every transaction, every short sale transaction, because the majority of our company's business is in states where short sales are the norm, not the exception, in California and Arizona and Nevada especially. We started getting involved in the short sale affidavits immediately as soon as they came out. The first round of the short sale affidavits were very, very difficult in nature in that they were put in place to reduce fraud, but the way that they were written, it put additional liability on the settlement agent, and it also put additional liability upon the realtors. And they had to be signed by everyone in the transaction, from all the realtors to the closing entity, and if title and escrow were different, then it had to be signed by both companies as well. So anybody who was part and parcel of the transaction had to execute the short sale affidavit. And that affidavit required them to certify information that, quite frankly, the realtors nor the title company or escrow company could or would have known, or they would not have been in a normal investigation. Namely, they wanted to make sure that the parties, it was a true arm's length transaction, there was no side agreements, and that the parties to the transaction were not related or connected whatsoever. And that's something that the title company would not normally know, because you could have different names and have the person still be brother and sister, for example. So people were just simply signing these affidavits without paying much attention to them. And it also created extra liability to the buyer and seller, and that a party to the transaction may not know whether or not they are signing this and violating the rule and the letter of the law at the same time. People were just randomly signing these documents. So we went to ALTA, and ALTA in turn went to NAR and other companies and other trade organizations, and were able to get the short sale affidavit modified. And that's what I want to discuss today. It's not so much focusing on the old affidavit, but really focusing on the new affidavit. Because in the old affidavit, it did require us to go and find out information that we would not normally have to find out. In the new affidavit, we do have to still turn over information that we know or should have known to the short sale lender, the company that's selling the property on the short sale. And we have to do this under a negligence standard versus before we had an absolute liability standard. So the old affidavits required all parties signing to the transaction to sign under penalty of perjury. Also, they would be liable for fraud. So your closers, for example, were signing these documents, signing these affidavits that said that this was indeed an arm's length transaction, that there was no conspiring amongst the parties, and they would have no idea, and yet they would be personally liable for any and all losses that would go along with that. And the actual Freddie Mac document itself said they would only be liable for their own loss, in that it would be the amount of the short sale that they would be taking. However, other documents and other lenders modified that particular section, and they put all sorts of consequential damages in there as well. So you had an almost open-ended measure of damages that your closers were signing to, and they were signing for themselves in an individual capacity, and they were signing in a corporate capacity. So your employees were basically taking on huge amounts of liability that they didn't know that they were taking on personally, and really they were unable to protect themselves. So the title companies had two choices at that point: sign the documents and get deals closed, or not sign the documents and have it go to other companies. And there was a wide variance of what companies would do. Some companies would insist upon modification of those documents or modification of the affidavit, and other companies simply signed them wholesale. That didn't work out, and that really slowed down the short sale process. And the whole part of the short sale process is that you want to make sure that the transaction moves along as quickly and as timely as possible, and this was really slowing the transaction down. So Altime's members were able to convince Freddie to clarify the affidavit, and they did so, effective January 1 of this year. A lot of the affidavit still is there. Namely, it has to be an arm's length transaction. The parties can't be in cahoots, so to speak, but they're only negligent, or they're only liable if they have negligent or intentional misrepresentation. And they are signing in a corporate capacity, not an individual capacity. So by making the change on the affidavit, it really allowed the affidavit to be to clarify the transaction. It allowed the transaction to move along more quickly, so that the closer and the realtors only had to disclose what they actually knew or should have known about the transaction. So if they didn't know that the parties were brother and sister, for example, or they didn't know that the parties had business dealings with each other, then you can go ahead and sign the affidavit. Before, it was a strict liability and absolute liability. So if the parties were related or had previous business dealings together, they were absolutely and strictly liable. Now they're not absolutely and strictly liable anymore. So under the new affidavit, which again went into effect January 1, 2012, the affidavit no longer is incorporated as an addendum to the sales contract. It is simply a closing document like any other document in closing. It still needs to be signed by all of the parties to the transaction. Namely, it needs to be signed by the buyer, by the seller, by the realtors, by the title company, and if we have a separate escrow company, by the escrow company as well. It also required the servicer to update their forms to comply with the revised policy. But I will tell you that that simply is not the case. Right now, we have the majority of the affidavits that are coming back are not coming back with the modified language. So as a practice here, the thing you really want to make sure is that you have a copy of the new Freddie Mac short sale affidavit in all of your closers' hands. Then have them match up that particular form with the form that is being used by the lender. If it does not match, then they need to be taking that upstairs to your legal department or your underwriter or whatever the case may be. But we are seeing about 50% of all of the short sale affidavits not match the current short sale affidavit that Freddie Mac put out there. And that's a problem. So we're actually having to go work with each and every lender to get them to modify their form in order to meet the new requirement. And again, the new requirement just says that the person certifying is certifying to the best of their signatories' knowledge and belief. So basically what they knew or should have known about the transaction. Is it indeed an arm's length transaction? And if they will not modify the document, you need to really go to the legal department of the lender, because they seem to be more aware of the modification of the law than the people who are processing these on a day-to-day basis. And again, that varies by lender. But again, we're seeing about 50% of all of the short sales simply not use the current form. And when the current form is not used, again, it brings in all sorts of old liabilities that were specifically taken back by Freddie Mac, and it still puts them out there. So you still have, even though Freddie Mac has modified the form, if the old form is used, you still have all the contractual liability that the old form had. And that is obviously a huge problem. In the new form, all it says is there's an arm's length transaction, the parties are unrelated, unaffiliated by business, marriage, or commercial enterprise. That does mean that if you had a former business partner and it was sold from business partner to business partner, then they have to set forth that business relationship. That is something that would be almost impossible for the realtor or the title company to know. And it also says that you can't sell the property for X period of time. Now, that becomes a bit of a problem, because if we're part and parcel of the transaction, what we're seeing is that some of these properties are being flipped. And if the property is being flipped, you have to be careful that you're not signing the short sale affidavit saying that this property won't be sold for a period of 90 days. Sometimes we're seeing 6 months. Sometimes we're seeing a year. But it should be no longer than 90 days. And that's where you need to make sure that you contact the lender and make sure they modify the affidavit, if possible, to state that the transaction may not be flipped for a period of 90 days as a maximum. If that is there, then you need to create a database to reflect when transactions close and how long the waiting period is, so that you do not inadvertently close a transaction before that 90-day period. What we've done is we actually have created a database of all of the transactions where we have signed these types of affidavits, and if a transaction falls within 90 days or whatever that period of time is, sometimes it's 30 days, sometimes it's 60, it all varies upon lender, then we are notified, it is notified through title out to the closer that they can't close the transaction, or the parties need to simply wait to close the transaction. So it is important that you maintain some type of database so you can verify that the transaction is closed. The new affidavit also says the borrower or purchaser will not receive any funds or commissions from the sale of the mortgage premises. So it is important that nobody is getting any money out of this transaction. Now, in a short sale, it really shouldn't make that much of a difference, because there's obviously not much money going out. One thing that we're finding is, in the event that they are not willing to sign the affidavit, it is just very, very important that the affidavit goes to the legal department, again, of the lender. And we have taken some of the affidavits and simply modified them and had all parties initial them, and then sent them to the lender and see if the lender will approve it. We have done that a handful of times, and it does work. So what do you do if you're presented with an old form? If they will not change it, I don't think you can close the transaction. And you certainly cannot let your closer close the transaction signing under the old form, because it does provide for personal liability of of the settlement agent, and you can't allow your employees to have that type of personal liability. So in my mind, you either have to use a new form, modify the old form to provide for the best of knowledge, or you simply cannot close the transaction. So to me, that is simply the best practice that you have going forward. And the only way to do that is to make sure that your escrow officer has at their desk the old form and new form, and make sure that they're able to sign the document without any problems. And again, it needs to go to the legal department if it's not. And it does make a lot of sense in that this is preventing fraud. There was a lot of fraud going on. And this has done a good job of eliminating a lot of the schemes that were out there. But again, what it was doing was creating liability for people who were signing the documents that didn't know they were getting the liability and really weren't signing on for the liability. So with a new short sale affidavit form, it does fix that problem. It's not perfect. In a perfect world, I think we would have preferred not to have any type of affidavit that we were signing, but we have to have something that says that the parties are unrelated and this is not fraud, and that this is the best we could get at the time. So we have it now. You have to use the new form, and again, if you don't have the new form, you need to get a copy of it absolutely as soon as possible, and then use it with every single escrow officer you have on every single transaction you have that's a short sale, and make sure that the new form is being used. And with that, Jeremy, that was quick, but that's about all there is to it.
Okay. Well, thanks, Bill. We had two questions, and they were both pretty much the same theme, and they were curious as to where can the new short sale affidavits be found. Is this going to be generated from their servicer?
Yes. The servicer should have the affidavits and should have the new forms. However, the problem that we're running across is that half of the servicers either don't have the forms or not using the forms right now. And that's really been the overriding problem that we've had. So you've had to go back and work with the servicers to go back to the lender and then tell them that, hey, this is the form that is going to be used. So yes, they have the forms. That's where you should be getting them. However, they're just simply not being used on a wholesale basis, and they need to be used on a wholesale basis.
And so that your advice would be just, if you do get one, make sure you're, as you said, comparing the new
Compare it. The best thing you can do is have your escrow officers compare the new form, and really, if it varies at all, you should have the legal department take a look at it, because if there's any variance whatsoever from the old form, or really from the new form, there's a reason for that variance, and it probably is to add additional liability to the settlement service provider. And so you need to be very careful about executing those documents. Even in a corporate capacity, you need to be careful about executing those documents, because it is going to be creating additional liability for the company and, in many cases, for the individual as well. And even though that Freddie has made the change, if you sign the old affidavit, it does provide for personal liability, and that's the thing you have to be the most careful about.
Another question came in, and a lot of these are centered around the old form, new form. The question is, how do you know if it's a new form?
There is no watermark or anything like that. I wish there was. What you need to do is get a copy of the new form, and what we've done is simply hand it to all of the escrow officers. If it varies at all from the old form, or if it varies at all from the new form, then they need to call, because the new form is pretty easy to see, because it does not have the signature blocks in personal liability, for example. It has signature blocks in corporate liability, and it also provides for the knew or should have known language in there. So you'll know it if you see it, but it's important that you get the new affidavits to your escrow officers, and really, for real estate companies, that they get those to their agents as soon as possible, so they aren't signing the old document with old liability. Any other questions?
It doesn't look like any more came in. Someone asked if sample language could be provided. Maybe Bill offer a little advice on how you worked with some of your servicers on how to maybe modify the language.
Sure. Actually, the modification that we did is very similar to what the new form, a new affidavit is. The change that needs to be made, or the two major changes that need to be made are, one, to put it into corporate capacity so that the person who is signing the indemnity, and this really is just an indemnity in the grand scheme of things, but who's signing the affidavit is signing it only in their capacity as either a real estate agent or signing it in their capacity as a settlement service provider and not signing it in their personal capacity. So you have to change the signature blocks, and that's what we did. We modified the signature blocks in order to create corporate capacity, not individual capacity, and then also modified the document so that as opposed to saying I, we changed it to the name of the company so that everything ran to the company and did not run to the individual themselves. The other thing that we did is that we changed the absolute liability language and stated that it's not a violation of the contract if the parties are related. For example, if they do have a business relationship, that is not going to be a violation, but only if the escrow officer who is signing the document knew or should have known of the prior business relationship. Do they have liability? So those are the changes that need to be made. And if you can make those changes, what it does, it really transforms the old document into the new document and does modify the old document to make it compliant with the new form. The other thing that you need to be careful of is that we're having a handful of lenders put certain things into these short sale affidavits that are a little bit troubling in that they also serve as escrow instructions. Namely, we're seeing, and this is rare, but we're seeing it on occasion, we're seeing that we're agreeing to issue particular endorsements or we're agreeing to do specific things on title. That's rare, but it does happen on occasion. If you see something like that, it needs to be addressed with the legal department of your company as soon as possible because that's not part of the affidavit. And some lenders are using the affidavit to bootstrap other issues that they're not getting elsewhere. They're bootstrapping it into the closing by virtue of the short sale affidavit. So again, you should have just the short sale affidavit, the new one, and it should be at the desk of every escrow officer that you have. And then if there's any variance whatsoever, then it needs to go to the legal department because there's probably a reason why. They're either using the old document, which is a problem, or they're trying to do something to create additional liability to the settlement service provider, which again is a problem. So it is important that this document really is at the desk of every person that is closing short sales.
Great advice, Bill. One more question. Question is if you've ever encountered or heard of a lender pursuing a title agent based on this short sale affidavit being signed.
That's a great question, and the answer is yes. I have heard, I have seen instances where a lender has gone after somebody, but in most of the instances that I have seen it was parties that truly were related and that the escrow officer knew or should have known. So yes, we have seen it, but it is in a rare set of circumstances that it has occurred. And most of the times we have seen it are instances where it was either fraud or certainly had the appearance of fraud. But these have not been wholesale implemented or wholesale litigated, not even close. Because, again, don't forget, these things only have been in place for a little over a year. So we haven't seen really the fallout of any potential liability yet. That may be coming down the future, down the path in the future.
Hey, all right. Well, thanks, Bill. I don't see any other questions coming into the queue, so thanks for the practical advice on this. As an added benefit to those on the call, the presentation will be available for download later this week on ALTA's website, and you'll be able to find it at alta.org/title topics. Again, that's alta.org/title topics. And just a quick note before we wrap up, I'd just like to everyone know that Bill will address this topic at next month's Business Strategies Conference in Louisville. He'll be partnering with David Townsend, president of Agents National Title Insurance Company, on the panel, Lender Instructions, What Am I Agreeing To? So you can go to ALTA's website for more information on that and to register. So that brings us to the conclusion of today's webinar. Bill, thanks again for joining us, and I hope all the listeners found the presentation useful.